All right. Hello, everyone. Welcome to our October 2022 Biz Essentials webinar. We're going to let everybody get settled on the Zoom login here, and we'll be right back and ready to get started. Okay, looks like we've got a good group already, so we're going to get going. Hello again, and welcome to today's Biz Essentials webinar. I'm Amy Stark, Director of Administration for FCSI the Americas. And we're very excited to have you here for this month's event. I have a couple of announcements I always put in at the beginning of our webinars. So for today, please use the Q&A feature on your Zoom window if you would like to submit questions for everybody. That's helpful. Also, if you miss anything on today's webinar, you want to rewatch it or watch a previous episode, these are all recorded and available on our website or through our YouTube channel. And remember, for those of you who are FCSI consultants, you are required to have 3 to 12, depending on the kind of member you are, CEU credits by the end of the year. So this is an approved event for 1 credit. So make sure that you are paying attention to your records so you know that you got credit for this attending today. And also but importantly, I would like to say thank you to Jackson Warewashing, who is our sponsor for today's event. Without our sponsors, we wouldn't be able to do these webinars. So thank you again to Jackson Warewashing. And now I'd like to welcome today's panelists, and I will let them introduce themselves. So welcome Steve, Jeffrey, and Mark, and take it away.
All right. Well, thank you, Amy. So I'm Steve Carlson with Rippey Associates, and this is a topic that's near and dear to me. And I'll let my associates introduce themselves. Mark, do you want to start?
Yeah, certainly. Hi, I'm Mark Ahmann. I've been in the insurance business for a little over 30 years. Currently at a company called Christensen Group, focusing on commercial insurance, liability, property insurance, workers' compensation, and errors and omissions. Jeff?
Yeah, Jeff Coleman. I am a structural engineer by background. That was 44 years ago, and then went to night law school, I guess 42 years ago or 41 years ago. But I practice as an attorney. I've defended architects and engineers for about 38 years and have negotiated a lot of contracts in that time frame.
All right. Well, thank you both, Mark and Jeff. I just want to say before we get started that Mark and Jeff are both very important advisors to our business. And I have to say pretty much everything I've learned about this subject is from Mark and Jeff. So I want to thank you. Thank them for the help that they've given us. So without further ado, we will get started on the program today. All right. So again, so what we're going to talk about today is one word that could put you out of business, and pretty soon you'll know what that word is. But what we're talking about today is indemnity clauses, which are found in contracts, and the ones that we're usually, what this membership is concerned about are the contract or agreement between the architect and the consultant. So this is one of the 6 things that we look at when we review that agreement. I'll quickly go through those, and then we're going to focus on the 5th one down here today. So we look at standard of care, insurance requirements, scope. Does it match what we put in our proposal, the same number of meetings, copyrights and uses of drawings? And then the important one is either sometimes listed as dispute resolution or indemnity, and the prime agreement. And the prime agreement is important for the 5th one as well, because we have to look, and we'll talk about that some more in a bit. But all right, and I would say, Jeff always tells me that all these are important, but I think it's only the 5th one that can really cause some financial risks for all of us. So, okay, indemnity language. I know when I look at these contracts, it's one of my least favorite jobs. You know, just because I'm not that familiar with it, or I don't feel like I fully understand all the language. So it's certainly helpful to have Jeff and Mark to have taught me how to understand what's in these documents over the years. And what I used to think was like, well, if it was a standard AIA document, I look at it, I go, well, these are all the same, right? I don't have to, it wouldn't be in there, wouldn't be something I'd have to worry about if it's an AIA document. But as I'm going to show you in a minute, there are many versions of the same AIA document. So it is important to look at every one of those things that are in those agreements and understand them. So here's a couple. So typical examples from AIA contracts. The first one, you know, this is, I mean, you're probably, many of you are familiar with the C401 2017. And I've just put in, usually into that agreement, it's in Article 8. This case, it's called Claims and Disputes. We zero in on the important part. Consultants shall indemnify and hold harmless. And this is the second part is also important, but only to the extent caused by the negligent act or omissions of the consultant. This one is pretty simple. This is there's only one thing that you're being asked to indemnify and hold harmless for, and that's errors and omissions. In addition, this one has the clause that the architect will also indemnify the consultant from any mistakes that they make. So again, this is probably the simplest one I've seen recently of the C401. This next one here, same document. So if we're just looking at it and saying, well, it's standard AIA, don't have to worry about anything. But look now, so we've got we still have negligent error and omissions or negligent acts, but now they've added in cost, damage, bodily injury, all kinds of horrible things, tangible property that you're also being asked to indemnify and hold harmless for. Then if you don't pay your workers' compensation or something happens with that, you're agreeing to, do the same for them. And then finally, if you don't pay your taxes. So, well, Jeff's going to talk a little bit more about later on about what other things are usually found in these agreements. But I just wanted to point out that, each one is different, even though it is a standard AIA document. So it's important to look at the detail. So you may also, okay, so another tip here, and it's what I learned is a while ago is that when you get these agreements, there's something at the back of it that says additions and deletions. And if you want to see what they took out or added, you can look at that. I mean, that's a little tricky. I think it's still important to read through the complete agreement. Here is, you may get one. I mean, some of the architectural firms, particularly the larger national firms, don't use AIA forms. They have their own. And this is another one here where this one includes the words that we really want to watch out for, was indemnify and defend, which is in the red underline here. And Jeff will talk a little more about what it means to indemnify and hold harmless. But the important thing we need to understand about defend is your liability insurance will not cover defend, and you can't purchase insurance that will cover the defense of a third party. And that's really what we're here to talk about today. So, all right. So, Jeff, I think this is
this is the start of my couple of slides.
Yeah.
So to reinforce what Steve just said, if you've got a standard AIA agreement and it has not been modified, and that's where you look at the deletions and additions report to see. But if you've got a standard AIA agreement with the language in it, you'll be okay. That's the main thing to remember. And in fact, the indemnity clause was not even in the AIA contracts until about 2017. And it was added by the AIA Documents Committee because they were getting so many bad and onerous indemnity, defend, hold harmless clauses that they thought they'd better put one in that was worded properly and insurable. So this has just been a constant battle. The two issues are defend and arising out of versus to the extent of your negligence. And if we go to the next slide, I can kind of set the stage for what we're talking about. Oh, now this is,
Is this the right one? So.
no,
I need
no,
to
it should
do the
be,
same thing again. This one?
there we go. So
Okay,
this is
sorry,
this
Jessica.
is another, yeah, this is another AIA clause, and I've underlined the important parts. This one says, shall indemnify and hold the owner and owner's officers, employees, etc., harmless, but only to the extent the claims they are caused by the negligent acts or omissions of the owner. And it does not include a duty to defend. This is okay. This is covered by 99.9% of your insurance policies. Basically, assume 100%. But now the next slide shows you the two problems that can be created with a couple of simple words. To the extent allowed by law, the architect shall indemnify, defend with counsel acceptable to the owner, and hold harmless the owner from and against damages, losses, and claims. And then it's for anything that arising in whole or in part out of your acts, errors, or omissions. So there's two problems here. One, you have no coverage for defend. Your policy only covers to defend you against claims, not anybody else. So this is something you'd be taking on, and this is why we say, you know, how to bet the company, because you'd be taking on the defense of your client with no coverage, and you don't have the money to pay for us lawyers to do that. Secondly, you're only covered for your negligent acts, errors, or omissions. You're not covered for anything arising in whole or in part out of your acts. So that's the second issue here that brings it within insurance. Now, the reason is your insurance policy has an exclusion for liability that you assume by contract. And these are liabilities you're assuming by contract. And then it goes on to say, unless you would have had the liability in the absence of the contract. So the first clause I showed you is the liability that you have even if you didn't have a contract. The second one is liability that you're assuming by contract that you don't have any coverage for. So that, hopefully that's clear. Now you might ask, if it's liability I have, if an obligation I have without the contract, why even have it in there? And again, the AIA put it in this last document cycle just to have a insurable indemnity clause rather than an uninsurable indemnity clause. Now, hopefully that all makes sense. And I confess that you might be approaching PhD level architecture, engineering, maybe even PhD level lawyering here, but that is the issue. And it really comes down to these couple of words that trigger it, that push it over into the area of no insurance coverage.
All right. Thanks, Jeff. So, all right. So, and that's kind of a good segue, Jeff, into the legal and financial liabilities agreeing to defend the owner of the architect. I don't know if you want to talk about that recent lawsuit we were talking about when we rehearsed yesterday. Or,
Well, I have had a case. This is the nightmare for the entire industry is what's called the CH2M Hill case out of California. CH2M Hill was a large consultant on a large project in California. It went to litigation, went on for a very long time, very expensive. And CH2M Hill had the bad indemnity clause with defend in it. Now in court, they were determined by the jury to be 0% at fault, no fault at all. But because they had defend in their contract on post-trial motions, they were required to pay all of the defense costs of their client, millions of dollars in defense costs, even though they were 0% at fault. This gets into a distinction between defend and indemnify. Defend can be interpreted to be more broad than the duty to indemnify, and this goes back to insurance law. But again, that if you put that word defend in there, that can be interpreted to be a requirement to defend your client from day one, regardless of whether you're at fault. That's the dangerous part of this.
okay, thank you, Jeff. So what is, I mean, so indemnify and hold harmless are okay, but what do those mean to the layman, Jeff?
Well, we're going to start slicing and dicing terms here, but hold harmless means that by contract, you have assumed another's liability. So they basically have no responsibility. So by contract, You're assuming their responsibility and their liability, and this is where you actively assume the liability. Indemnify means after the fact, to restore a loss, to save harmless, to make good, to compensate for a loss. It's after the fact, or to reimburse somebody for the cost of a loss. Now, again,
Okay.
as long as that's all to the extent of your negligence, that's an obligation you'd have anyway. In other words, if you make a mistake and that's 45% of the cause as determined later by a court or an arbitration panel, then you reimburse your client. You could reimburse your client for 45% of the costs, or the percentage of the costs. And that could include attorney's fees after the fact, but not before the fact. So that's the really distinction there. It's for purposes of our discussion, it's what lawyers would call a distinction without a difference, meaning you got to pay for somebody else's liability and hold them harmless so they have no exposure. That's not where you want to be.
Yeah.
Unless it's
Okay.
to the extent of your fault.
Yeah. Well, these two words are going to become important when we talk about how to negotiate with an architect or an owner regarding the indemnity clause, right? Because I think that when you and I talk about this, Jeff, what I think an architect cares about is that you're going to stay in. If you make a mistake, they want to be sure that you're going to be working on the solution, so that you're going to stay involved with coming up with a solution, and then take financial responsibility, hopefully through your insurance, for any mistakes that you made. So I think some architects think that they need to put defend in there in order to ensure that you're required to, correct whatever error remissions we might have made. So, all right, so I'm going to go. And now, so this is another definition or legal term that we have to understand, right, Jeff? It's a duty to defend, and what does that mean? So,
yeah, it's a really dangerous word, because the insurance law is the model where the duty to defend is broader than the duty to indemnify. So what does that mean? That means that if an insurance company writes an insurance policy and there's one little issue in a summons and complaint that requires coverage, potential coverage, then they have to defend the whole case. So that's the case law that gets used when they look at these indemnity clauses. And so the duty to defend in an indemnity clause is also broader than the duty to indemnify. So like I said, the extreme result was CH2M Hill, 0% at fault at trial, but agreed to defend their client. And the court ordered they pay all those attorney's fees of their client, millions and millions of dollars, because of the word defend.
okay, and I have seen this in proposed agreements before. We definitely want to avoid that. So,
Yeah, and I guess the frustrating part of this, Steve, you touched on, is that assuming most of you are going to be working for some other design professional, usually an architect, a lot of times they will have already negotiated and agreed to these terms, not knowing what they're doing, and then expect to pass that on to you, which we'll talk about near the end.
yeah.
And that puts you in a really tough spot. I mean, there's no doubt it puts you in a really tough spot if they've made the bad decision to agree to these obligations. But that doesn't change the fact that you have no coverage for it. Neither do they, by the way. But again,
Right.
that you can't. I counsel you or advise you, don't let their bad decision become your bad decision.
Well, that kind of
Well,
leads
this
us
is
into.
and yeah, I'm sorry. We had the Star Trek mind link here, because what we're talking about is the flow down clause. So what this says is, they may come to you, the architect will come to you and say, okay, and in addition to all these other provisions we've negotiated, you now have to agree to the same provisions I've agreed to in my prime agreement with the owner. So maybe you've negotiated the indemnity clause you wanted, but then at the end it says, and you're also agreeing to everything that I've agreed to with the owner, which brings you back to maybe a bad indemnity clause that they have in the prime agreement. So you can't agree to this unless you actually see the prime agreement and see what's in it. I'd prefer that you say, if there's any inconsistencies between the two, that your agreement governs, not the prime agreement. They might fight back on that. You may have to add a provision that says, okay, we'll agree to the provisions you've agreed to, but not indemnity and other issues that we carve out. Again, we come back to, what's covered is to the extent caused by the negligence of the consultant. Now, the good news here too is as in the area where you practice the food service consultant and layout and consultancy and so on, you don't have as much exposure. I mean, nothing you're going to do is going to make the building leak. Nothing you're going to do is cause a structural collapse. Nothing you're going to do is it's going to cause footings to sink. I mean, the big exposures we have typically don't flow out of what you do. So it isn't quite as risky as some of my other clients. But again, if you agree to defend, you could be agreeing to defend your architect client from day one in a lawsuit.
Yeah. And I think, Jeff, the example that you're talking about where the prime agreement does include, where the architect did agree to defend the owner. I have only seen 2 of those, well, since you've taught me to pay attention
Look
to
for
that.
them.
Yeah. I think the point I want to make about looking at the prime agreement is in many cases, at least when I've been negotiating, when I get a sub-consultant agreement from the architect and it says defend, hold harmless, and indemnify, I immediately look at the prime agreement. And most times, they have not agreed to defend the owner. They've only agreed to hold harmless and indemnify. And I think that's probably the quickest solution to negotiating these things, is say, hey, I'll agree to what you agreed to. Don't ask me to agree to something you didn't. So.
Yep, Steve, that's a really good point. That's kind of the flip side of the flow down clause is look at the prime agreement, and if they've done a good job negotiating, doesn't include defend, only to the extent of their negligence, then tell them, look, I'll have what you're having. I'll agree to what.
Yeah, exactly.
Yeah.
So I think that's probably, I think that's probably the most important strategy to take for negotiating these. The other ones we talked about is, as we looked at that one indemnity clause, it was the C401, had a variety of things that they were asking us to indemnify and hold harmless. And if they're asking for you to defend as well, you have to check with your carrier. In my case, I'll be checking with Mark and say, what about general liability? What about, physical harm or property damage or workers' comp? Do some of my other, either my general liability or my air emissions insurance, will they pay to defend a third party for that?
Right.
So that's, we have to look at. And then again, of course, as you said, Jeff, make sure that whatever they're asking you to do hopefully does not say defend, but it's only to the extent of caused by negligence.
Right.
Not the other language arising out of. So I'm going to keep going here. So
Steve, you've learned a lot, Steve.
a lot of it became clear yesterday when we practiced. So as I said earlier, I think most architects will, in my experience, add that in there because they've had a bad experience with another consultant. I'm sure they weren't an FCSI member who, told them, okay, you solve the problem, tell me how much I owe when you get it figured out. So I don't think any of us would do that if we belong to FCSI. But and I think as you told us, Jeff, hold harmless and indemnify means you're agreeing to help solve the problem and take, for financial responsibility for what we're responsible for. And I have to admit,
yep, the standard AIA clause basically says that to the extent of your negligence, you're going to be part of the solution. Yes.
Yeah. So, and I've got 2 now. One I found out about yesterday where the architect had agreed to defend the owner, and had a conversation with yesterday and say, well, yeah, we tried to get that out of there, but it's too big of a project. We're not going to walk away from it. So we agreed to it. So I got to figure out what I'm going to do. So sometimes, you can't always get it out of there, but obviously you need to be very careful that you don't. Mistakes happen. I'm sure we've all had them, but when make sure that when you're in this situation, you really don't want any mistakes that you can be liable for. So, all right. Well, Mark, we're finally getting a chance to let you talk here.
Oh, good. It's about time. Yeah, Jeff, thank you for all that information. That's, I don't think you can ever learn enough. One thing about, I think, law, and I'm not a lawyer, but another thing about insurance is you'll never see everything in this business, and there'll always be something new. and something will always change. So, some of the big things that I thought were important to talk about, and Steve brought up, the question is, whose defense will the insurance cover in case of an error or omission? And, there's probably an easy answer to that. We're, policy, I think, first of all, I think we all have to understand that none of them are the same, but their intent is. So the intent is to cover you. That's an important term. You for your negligent acts, errors, and omissions with regards to the professional services that you provide. So professional services is also something that we need to make sure that our clients look at the definition and agree to the definition of what are your professional services. So with that, I think if we understand who you are, who's you, how is it defined in your policy? I think you all need to really understand, take a look at your policies, talk to your agent, who's defined as you. And I would assume most of you are, I shouldn't assume, but most of you probably just have one entity, and that's the named insured on your policy. But I've seen in many cases where there's multiple entities that are supposed to be insured on a policy, and in some cases, not all of them are. So have that if there are multiple entities involved, as a multiple use involved, make sure that all those use are covered under your policy. So look at who a you is, and look at who and how the term professional services is defined in your policy. Make sure it's not too limiting. Make sure it's not. You really want just a very broad, open statement of what your professional services are. So understand those two definitions, and I just wanted to set that real quick. An E&O policy, the bottom line is, if you can cover, or if you can trigger coverage, the defense is there to protect you. Okay? You, not others, not third parties. So we're looking at coverage where if you can trigger a claim in your policy, meaning that if there's a claim that happens during your policy period and you're able to get that claim submitted to your carrier within a reasonable time, usually that's during the policy period, during an extended reporting period, or within 30 days of that policy expiring. But all policies are different. Make sure you understand those conditions in your policy. And you can prove that there's a written demand for compensation. Most policies then will provide you defense. Okay, and most policies, and I've seen it where it's not, most policies are going to provide you with the duty to defend you again. So just be careful about you, who's you, and that's where you will get defense for your negligent acts, errors, and omissions with regards to your professional services. The next question on the slide talks about is insurance available to cover defense of a third party in case of an E&O? Straight out answer is no. I would assume not. In most cases, 99.9% of the cases out there, it's really not. If you look at a policy and it shows that there might be some party coverage there, as Jeff had pointed out earlier, there really is not coverage. The depth of what's available on that policy is not what the owner or the architect and engineer is looking for. It's not going to be what is in that contract if that's a requirement for you to do. So is insurance available to cover defense of a third party in case of the E&O? You have to assume no. And that's why it's so important to follow the guidelines that Jeff and Steve have provided you earlier with regards to that. So moving on, whose defense will the insurance cover if in a copyright infringement lawsuit? So this is kind of taking away from defense and duty to defend and indemnify, but focusing on copyright infringement. And I'm also going to say, take a look at your policies. Again, be careful here. Not all policies are the same. You will find that there are a few policies, insurance policies out there for E&O that might extend coverage for copyright infringement. But with regards to that, understand who are we defending? And it's you. We're not going to extend defense to a third party under this agreement either, if you happen to have coverage extended to copyright infringement. Really kind of what you want to look for is language in your policy. This is for your protection that would say something like, we agree to pay on your behalf all sums to which you become legally obligated to pay because of, and then it will start talking about what kind of infringement coverage you get under the E&O. So you may get an extension under your E&O. Not all policies are going to provide that. So you do have to look at your policies real closely to see where that coverage comes from. Have that conversation with your insurance agent to see how it might extend. Now, without going to the next slide talks about general liability.
You want me to
It's
go to
very
the
similar. Yeah, you don't need to forward the slide, but there's a very simple question with regards to whose defense will the insurance cover copyright infringement lawsuit as respects to general liability. Now, general liability, so we've been talking about errors and omissions. General liability policies cover your premise, your operations, and they can cover products and completed operations. The standard policy does, but I've seen where policies have not extended to products and completed operations. But for if they do, they're going to cover you for bodily injury and property damage, as well as personal and advertising injury. But be careful, again, I've seen policies exclude the personal and advertising injury. If you don't have personal and advertising injury under your general liability policy form, you're not going to find coverage for copyright infringement. If you do have it, you're going to find very limited coverage. The general liability policy form itself while it does provide copyright infringement coverage, a lot of it has to do with advertising. So advertising word of mouth, advertising and writing. An example of a claim that I saw where this kind of coverage would kick in under a general liability policy form would be, so we've all seen the ads for home and garden shows. You know, in Minnesota, that's where I'm from. These shows start popping up in late winter, early spring. We've got the home and garden show, home and landscape show, yard and garden show, you name it. But as these shows develop and new companies start new shows, they move into new towns where maybe there's already an existing show. So I've seen where there's been a home and landscape show, and then the home and garden show moved in, and the home and landscape company basically sued the new company for the use of the word home. So here they're advertising, we're the home and landscape show. The new company comes in, we're the home and garden show. There's a big squabble. So a $25,000 cease and desist letter went to the new company, and they had to defend themselves. They were able to find coverage for that under their general liability policy form, under the advertising, personal injury and advertising coverage. So again, it's infringement of intellectual property rights, barring, just understand there's no coverage for patent infringement. So you will find that, and you can also find additional insured language, which could possibly extend coverage for that. But again, just understand that coverage is limited under the advertising and personal injury coverage sections of a general liability policy form. So whose defense will that insurance cover? We always have to assume it's you. If written appropriately, there may be some defense for outside parties, but assume it's just for you. Whose defense will the insurance cover if in a product liability lawsuit? So again, this is being asked under the professional liability coverage section of these sheets, but it's also asked again under the general liability section. So I'm going to answer this in two parts. So when you think of product liability, what do we think? It's usually bodily injury or property damage that occurs due to a product failing. The product might cause injury. Pacemaker quits working. What's that going to cause? Bodily injury. The pedal falls off on a bicycle. What's that going to cause? Bodily injury. Okay. Could also cause property damage. didn't stop in time and it ran into a car and caused damage. So we're going to answer this in two parts. So from a professional liability standpoint, with regards to product liability, you're going to usually find a very strict exclusion for product liability under E&O or professional liability policy form. So most policies are going to say, no, we don't cover product liability. However, with that being said, you might find an exception where there's contingent bodily injury and property damage coverage that's extended onto your professional liability policy form, where if your professional services and what you did for your client, your services that you provide to your client for a fee, if those cause ultimately, in turn, a product liability claim, there could be an exception for that contingent liability, where coverage would again then be there for you, not again for a third party, but for you. So take a look to see if you have some sort of contingent bodily injury or property damage. If there is damage, now if you did your work, I just want to maybe I'm trying to get out of the thinking about product liability as I see it as an insurance agent, maybe just kind of saying property damage. In your work, your professional work, if you did something, you could easily, incorrect, you goofed up and you made an error. If you do that in your professional services and the design didn't work, and in turn, the stove that you had installed is now causing whatever is sitting above it to melt away. There we have property damage with regards to your, and that's really stemming from your work. So can you find some coverage there? Will you find defense there? Yeah, again, for you. So just be careful of that. And as we shift over to the general liability policy with regards to the defense for product liability, understand that most general liability policies are going to exclude professional services. So knowing that, when it comes to product liability, if you install or modify, touch, amend, adulterate, whatever you happen to do to a product, if you change it, you could find yourself, and I doubt it, if most of you are doing design work, you're not really touching the product. But if you do, that could fall under your need for product liability. The liability could lie within you because you amended that, altered that product in whatever way you did. You're gonna find defense under your general liability policy for product liability, but not for professional services that you render. So you do have to understand that professional services will be specifically excluded under a policy, and also faulty workmanship. So if you happen to be touching or amending or modifying that product that you're installing, because that's your workmanship, you may find yourself without coverage under a general liability policy form and may have to fall back under the E&O or a financial injury type of lawsuit. So
all right.
Well,
Mark, we've got one. I didn't mean to interrupt you, Mark, but we've got one more slide. Amy, how are we doing on time? I mean, one other questions I asked for Mark, which I seem to be kind of appropriate here, is, because we've got Mark, to tell the audience, what do you need to do in case you have a claim against your professional liability insurance? Do we have a couple of minutes for Mark to address that, Amy?
Yeah, absolutely. We've got, we're still about 15 minutes left. So absolutely, definitely have enough time. Yep.
Yeah.
Okay.
So I want to make sure there's a little time for question and answer, right, Steve?
Yeah.
Yeah. So do you want to jump one more?
Yeah.
There we go. Yeah. So what steps should a consultant take if they realize they have made an error in omission? Okay. So I think I'm going to respond just based on all of the questions together, because it really is a process. Kind of what you need to do, what you should do. I think what's real important is if you know of, or you see that you might have an error or omission, you need to start documenting. You need to get your documents in a row. You need to start pulling that information together and investigate kind of what had happened. And in my experience, I believe that you need to maintain open communication with your client at all times. If you duck and cover, that's just going to make things worse. You don't want to make them more angry than they really are. In addition, and I've always said this, is get in contact with your own attorney. Don't rely just on insurance companies and their attorneys. You want to talk to your own attorney about what's going on. You want them in the loop. Again, for many reasons that we've already talked about, they'll want to take a look at that contract. And you may have a situation where your insurance company adjuster maybe isn't playing fair, maybe is just not responsive, and you want to make sure that you've got your attorney on your side helping you through this process. So you do want to establish communication with your attorney early on. And then obviously, if you think that you need insurance, if it's not a little error, if it's something that is going to take a little bit of work, something you can't just settle real quickly, you're going to want to put your insurance company on notice. And they may not open a claim right away. They may not open a claim until you've actually received a demand for money or you've been sued. But you will want to at least, you want to file a notice of circumstance. And the reason you want to do that is policies, policies are issued typically on what's called a claims made policy form, which means the policy that's in place when a claim is actually made is the policy that would pay for that claim. And there's stipulations in those policies that say if you don't file a claim within a timely manner, we may not pick up coverage because you didn't follow the rules. And that's why you need to understand the rules of your policy. So one of the other things you do if you've made an E&O claim, I've said, look at all your stuff, open communication with your client, call your attorney, well, call your agent too. You need to talk to your agent and get to understand, if you have, which you should have already done, but understand the conditions of the policy form. So you understand when a claim needs to be filed and how long you have to do that. Does it say within 30 days? Does it say as soon as practical? All policies are different. Again, I can't reiterate that enough. Every policy, especially E&O, is going to be different than everybody else's on the street. And that's just the way that's just the nature of the beast, unfortunately. So we're gonna want you to have an open communication. But again, if an adjuster can't open a true claim, at least you want to put them on notice. And some of the things that you want to share with them, so you'll want to have this information or details about the time and place, kind of what happened, just the nature of the incident that happened, how you became first aware of what happened, and the reasons that you believe that it might turn into a claim itself. Those are real important that an adjuster understand that. You might want to share with the insurance company who might be the claimants, if you have an idea, the owner of the project, the architect and engineer, or even a third party. Think of a bodily injury claim that happened on a job site. And then the indication of how big you think the claim might be. And I think you gather that from the data that when you investigate the incident right away. So some of the things that you're going to find covered under an E&O claim. So let's say the claim goes in, we have it covered, or the insurance company agrees to start defending you. They're going to provide you defense. Okay, this is covered. You're going to get defense. They're also going to pay on behalf all those sums. Hopefully, this is the language you want to see in your policy. They're going to pay all sums that you become legally obligated to pay because of your claim. So that's the kind of language we want to see. That's the kind of language you would want to see in your policy, where we also then have the duty to defend. So you're going to look for that language as well. And then in some cases, and you got to look at your policy real closely, there's some coverage extensions that might say then we also could include third-party legal and professional expenses, post-judgment, and then some really miscellaneous coverages like bail bonds or penal bonds. Hopefully an E&O case doesn't get into that, but that's something that you want to look for. And then icing on the cake, look for withdrawn fees coverage. So if you have had the client, they may quit paying you. They may owe you some money for the work you've done, but they may quit paying you. So look for, withheld fees. I think I said withdrawn, but I meant withheld fees. So that's another thing to look for in your policy. And kind of the last question here is, what has to happen before an insurance company will pay for correcting an E&O? We really want to take a look at everything I just talked about in filing a claim. Some claims are going to be relatively easy to settle. This is what we did. This is what happened. We should have done this. We meant to do that. All we do is slip something out, put something in its place. That's not always the case. Sometimes you can't easily slip a piece of equipment out, put a new piece of equipment in. So, and the damages might be, by the time you discover the error or omission, you could be too far along in the process where you might cause a financial injury because of a delay in opening. There may be all sorts of additional work that needs to be redone because of an error. That can get fairly significant. There may be problems with the adjustment of a claim that could delay it. Claims can get into a mediation, arbitration, possibly even a jury trial. And that's, so what has to happen? It just depends. I think this question is so open-ended, but
sorry about that, Mark.
Nope. And I'm okay to agree with it. I think we have to understand that there is a huge spectrum of claims from one end to the other. But in simplistic terms, an insurance company needs to investigate. And they're going to investigate on those 5 items that I told you to kind of put together that an adjuster is going to need. They're going to look at contracts. They're going to look at everything before they're able to make a decision to pay a claim. So, and that isn't done overnight. So it depends on how complex the claim is, how soon payment can be made towards. So, and we have to prove, the plaintiff needs to prove the financial injury. And we have to quantify that. So once we qualify, we have to quantify, and that will take some time. So
okay,
Mark, that answers those questions.
Yeah, thank you so much, Mark. I'm just we'll stop here, and I want to make sure we leave 10 minutes for questions because I know it's a lot of very dense subject matter. I would just say, I'm just thinking about this. I think what we want our audience to understand, 2 takeaways. Don't agree to defend anybody. And number 2, we're in the advice business. Make sure you get good advice from your attorney and your insurance agent to make sure that you're not, because one thing we didn't talk about is I think most insurance companies or your agent can help you assist in reviewing contracts as well, right, Mark? I mean, some of the carriers have phone numbers that you can call or people you can talk to say, hey, is this covered by my insurance?
Yeah, sometimes they do. Sometimes there's limitations. Maybe they'll do 2 a year, no more than 2 months of their time. That's from an insurance company standpoint. Agents will spend a little more time helping you understand what to look for and what not to look for in policies or in contracts, and how policies can or cannot help you with that. So.
Okay. All right. Well, hopefully everybody's either overwhelmed or they have a lot of questions. We'll have to find out.
So I do have a couple. The first one is, what is a typical length of coverage required for E&O post-construction?
Does that?
Go ahead.
Are we looking for something that would be in a contract? I mean, are you looking for what do you typically see in a contract as far as how long we need to maintain coverage for?
If the person who asked that question wants to type it into chat, that would be helpful. That came in through the Q&A.
Yeah, I can address that, I think. The issue with professional liability insurance, E&O cover, errors and omissions coverage, it's claims made, so you have to keep buying it every year. You don't have coverage next year, even for something you might have screwed up this year. You only have coverage next year if you bought another policy for next year, because it's the policy in place when the claim is made that provides the coverage. So you have to keep buying it every year. Now, you might see contract provisions that say the consultant agrees to provide professional liability insurance coverage during the project and for 3 years afterwards, or for 4 or 5 years afterwards. Statistically, most of the claims occur 3 years after completion of the construction. So that's sometimes a contract clause, but just understand that to have coverage, you have to keep buying it every year. Now, when you retire or go out of business, you can buy what's called a tail policy that will cover you for 3 years and then expire. So it's a 3-year policy, but you're not doing any business during that time. It's just a tail to the other policies. Hopefully that addresses the question.
Yeah, and I've got the chat up too, and I see that they're looking for, yes, what's typical in a contract? What's a typical length? And you gave a couple of answers that were maybe 3 years, maybe 5 years.
Yeah.
What do you see normal?
Well, 3 years is common, but it varies. It's all over the map, and it's usually going to be the sophisticated clients who are going to have that provision in.
Okay, I had another one. Does general liability typically cover any damages as a result of NDA agreement violations?
Oh, good question. Non-disclosure, confidentiality agreements. Mark, do you know?
What kind of damages are we talking about?
Well, that's the other issue, is how do you define the damages? But if you're accused of breaching a confidentiality agreement, I'd have to look at that. I'm not sure. Do you know?
Well,
I'm not sure.
This is focusing on general liability. And remember, general liability is covering you for your premise, your operations, your products, your completed operations as respects to bodily injury, property damage, personal injury, and advertising.
Yeah, okay.
Remember, well, the bodily injury and property damage coverage extensions, so that it's got to be a bodily injury or property damage. So I don't know how that would happen as a result of an NDA agreement violation, but let's maybe a misunderstanding.
And it might be just a breach of contract for which there's no coverage under either the E&O or the GL policy.
Yep. There may not be coverage under anything. You know, if the breach has nothing to do with the professional services that you're providing, your fee as defined, or your professional services is defined under your E&O policy, and there's no financial injury. Well, there might be a financial injury if you say it's an NDA agreement violation. They may be able to substantiate something there, but yeah.
So James asks a question here. What if you want to look at switching insurance companies? Do you have to continue the old company till 3 years past the last project? No, you can switch insurance companies at any time, but I would advise you to talk to your broker and talk to your attorney, and they will likely advise you to be sure before your policy expires to report any incidents that could likely lead to a claim, just so it's covered under that policy and you don't get a gap between two carriers. But no, you can switch carriers at any time. I don't advise you to do it often, because there is somewhat of a loyalty factor. If you switch carriers every year and then there's a downturn in the market, you know, I have seen companies get dropped by carriers. So I would try to find a good carrier with a good broker and be loyal to them. But no, you can switch anytime. One
thing, if you do switch, the new insurance company, you'll want them to pick up your prior retroactive date or dates.
Yeah.
Have retros based on, you know, if you've increased limits over time, you might have 2 different retroactive dates. Make sure that those carry forward onto your new policy.
Yeah, your policy covers claims made during the policy period for acts, errors, and omissions that occurred after a retroactive date. And that date needs to be preferably the inception of your company. In other words, when you started business.
Are there any other questions?
Looks like we've got a few more accumulating in there, so.
I got one, just while I have a moment. It isn't the topic of this program because we can't cover all 50 states, but some of the states do have anti-indemnity statutes that you should look for in your state. And then, of course, it only applies to projects in that state. So something to look for and ask your attorney about.
Yeah, that's something, unfortunately, Minnesota is one of those states for us, so, it says that we can't get a Minnesota architect can't require us to defend them in an indemnity clause because there's no insurance available for that, so.
So here's
that's sort of
a question by Anonymous, Mark. It says, the question was related to social media advertising if you disclose confidential client name or released as a photo that violates an NDA. So is that something that might fall under the advertising injury coverage?
Maybe and maybe not. I mean, as far as confidential client information, names, personally identifiable information, personal health information, you might want to take a look at like a cyber liability policy for breaching that kind of protection for breaching that kind of data. If, again, under a general liability policy form, you're looking at the advertising injury and personal injury. Well, let's not even use personal injury. Personal injury is libel, slander, defamation. You hurt my feelings kind of thing, not the sticks and stones, but the kind of coverage where advertising covers, again, for inadvertent copying by business of another party's creative content. Okay, so release a photo that violates an NDA, probably. Again, it depends. So if this is somebody's particular information, we might be able to find you coverage under the advertising injury for releasing a photo that violates an NDA. Again, that's going to be, it's going to be discussions with adjusters to make sure that there's some sort of protection that they'll be able to that could trigger coverage. But when we talk about confidential client names or personally identifiable information, we're probably at that point talking about some sort of data breach coverage, and that you're probably going to find it under a separate policy, maybe, if it's written right.
Okay. All right. Well, we're right at time, so I'm gonna have us stop right there. But obviously, very good discussion, and definitely some stuff we can think about doing for future webinars. So thank you again for joining us today, and thank you again to Jackson Warewashing for supporting this webinar today. Don't forget, as we look ahead, we have, and I'm going to turn my camera on so I can see you all. Don't forget, as we get closer to the end of the year, we are looking forward to seeing everybody at the symposium in January, right before NAFM starts. So we are being in Orlando, January 30th and 31st. You're probably starting to see some emails about that. So make sure you register and join us. Thank you again to Mark, Jeffrey, and Steve for the panel today. This was an excellent discussion. I am really looking forward to hopefully doing some more like this in the future, and we may be reaching out to get some more content from you guys. So again, thank you all for joining us, and I will see you in January. All right, bye-bye.
All right. Thanks, Amy.